after being accused of pressuring the Justice Minister to intervene in a criminal case. Pressure is now piling on the Prime Minister's office to explain exactly what went down. The opposition is calling for an emergency meeting and an ethics probe to determine whether the PMO tried to help SNC-Lavalin avoid prosecution. The CBC's David Cochrane has been following the story for the past few days and joins us now with the latest. Hey, David, thanks for being with us. Appreciate it. Let's walk through sort of the fallout on day 2 today.
Yeah, day 2 is when the opposition started to gang up on the government in a very organized way. So you have 2 calls for specific actions. It started with Andrew Scheer, the Conservative leader, had a news conference today saying we need an emergency meeting of the Justice Committee. We have 9 senior government officials that were name-checked at least once probably in the Globe and Mail article, and they want them all to testify at a committee next week. And the Democrats have backed that, and they've also called for an ethics probe. So Scheer and Singh were both out today. Here's what they had to say.
MPs have a duty to determine what exactly happened here, and Justin Trudeau and his office must be forthcoming. If the Prime Minister has nothing to hide, as he has suggested, then he should have no reason to fear these individuals appearing before the Justice Committee.
All this cries out for an investigation. We're asking the Prime Minister, if there's been no wrongdoing in this situation, to invite the Ethics Commissioner to have an independent investigation to get to the bottom of what happened.
So the NDP have written a letter to the Ethics Commissioner asking for an investigation. Scheer has said that if the Liberals vote against the idea of having an emergency committee meeting, then it's a clear sign it's a cover-up. The 9 people you want there, if you were named in the Globe article, other than like Bob Fife, Stephen Chase, and Sean Fine, they want you to testify. So Jody Wilson-Raybould, David Lametti, the former and current Justice Ministers, Katie Telford and Jerry Butts, the Prime Minister's senior staff, Michael Wernick, the Clerk of the Privy Council, Kathleen Roussel, the Director of Public Prosecutions, Jessica Prince, who's Chief of Staff to Jody Wilson-Raybould, and Matthew Bouchard and Elder Marcus, senior advisors to the Prime Minister as well. They want all of them to testify at an emergency committee meeting. Now, the Liberals have the majority on that committee, so it will go to a vote. We have to find out how they will vote for it. I spoke with Anthony Housefather earlier today. He is the chair of the Justice Committee. He says we'll convene a meeting next week, and that's when we'll make our decision. Liberal majority, opposition requests. That's going to be an interesting vote on whether or not they decide to go ahead with such a thing.
It sure will be. Lots of questions as well still directed at the minister, sort of at the center of all this, Jody Wilson-Raybould. I know you've been asking lots of pointed questions to her office. There was a statement released today.
Yes, there was a no comment said to our Chris Rand yesterday, and a statement that kind of doubled down on the no comment but put in legal terms. Here's what Jody Wilson-Raybould had to say. She says, as a former Minister of Justice and Attorney General of Canada, I am bound by solicitor-client privilege in this matter. So even though she is the Minister of Veterans Affairs, she says in her former role as the government's lawyer, she will not be speaking on this, which raises some questions about what's going on with David Lametti, perhaps, because he is the new government lawyer as the new Attorney General and the new Justice Minister. He has been speaking quite publicly and quite frequently on this story since it broke, including in an interview with our colleague Chris Hall on CBC's The House. Here's what David Lametti had to say today.
Let me ask this then. Your predecessor, Jody Wilson-Raybould, has said nothing since the story broke. What does that tell you?
I can't speak for my predecessor in terms of what she says or doesn't say publicly. I think she did a very good job as minister. I'm following, in effect, I'm completing the things that she completed many of the things in her mandate letter.
But I want to understand this. She can stand up and answer a question if asked. She can put an end to this by saying, I wasn't pressured. So
again, I can't speak for her. The Prime Minister's been clear. I've spoken to my experience. I think Canadians can be reassured that there has been nothing inappropriate here.
So it raises a lot of questions of where does privilege begin and end? Because if the Prime Minister is saying it, Arif Virani was answering this question in the House today, David Lametti is saying there was no pressure applied. He's the government's lawyer now. Jody Wilson-Raybould says she can't because privilege exists. I emailed the Prime Minister's office and said, will you waive this privilege and allow her to speak publicly? They said they told me if we have anything to add, we will get back to you.
We'll be waiting on that response. Thanks, David. The CBC's David Cochrane. So will we ever hear more on this from Minister Jody Wilson-Raybould? And if the Prime Minister's office officials agrees to appear before the Justice Committee, what answers are the opposition looking for? And joining us now, Marco Mendicino is Parliamentary Secretary to the Minister of Infrastructure. In Toronto, Lisa Raitt is the Deputy Leader of the Conservative Party and Justice Critic. And the NDP's Justice Critic, Murray Rankin, joins us from Victoria. Hi, everyone. Thanks very much for making time for us. I really appreciate it. Mr. Mendicino, I'll start with you. I know that you are a lawyer. Does attorney-client privilege extend to Minister Raybould's ability to say, no, I was not pressured by the Prime Minister?
Well, let's start with the principle itself. And attorney or solicitor-client privilege, as it's called here in Canada, is a constitutional principle. It affords the Attorney General to provide advice to the Government of Canada, and obviously for that reason it has to be respected. I'll come back to what I think is the broader question, which is whether or not there has been any pressure or any attempt to exert some influence inappropriately to provide some direction to the Attorney General, formally or presently, and the Prime Minister has stated repeatedly with much integrity and because of his respect for that office, there has not been.
Actually, the Prime Minister only used the word direct. You're the one that went further last night and said that that also included pressure. On the question, though, of attorney-client privilege, I don't understand how it extends to something that didn't happen. Why couldn't Minister Raybould, come out and say, no, the Prime Minister did not pressure me? I don't understand how that's covered by any sort of privilege.
Minister Wilson-Raybould has stated that she took great pride in her work and continues to be a member of the team in her new portfolio as Veterans Affairs Minister. Obviously, that work is very important to them as well as to the rest of Canada. And when it comes to the principle of solicitor-client privilege, it's something that I know that she takes she puts a lot of value in, as does the Government of Canada, and we will continue to respect not only the independence of the Office of the Attorney General, the independence of the Public Prosecution Service of Canada and the judiciary, because we respect the justice system.
But that doesn't answer the question of whether or not, under a legal understanding, does attorney-client privilege extend to something that never happened?
What I would say is that this is a principle that we take great put a lot of faith and a lot of value in, and obviously whatever positions will be taken will be done so on the full consideration of the Government of Canada.
Ms. Raitt, Minister Raybould did come out today and said that she, basically the only statement that she provided, I guess as a reason to why she hasn't said that this is false, is because of attorney-client privilege. Could that be the case?
Well, I can only take it on face value what she said, but the beautiful thing about solicitor-client privilege, the client can waive. And I don't know who her client is in this case, perhaps the people who are putting pressure on her. When we were faced with the same issues in our government, the Prime Minister at the time, Mr. Harper, he waived solicitor-client privilege and allowed anybody to see all the documents. And I think that's what this government should do. Whomever is the client should waive the privilege and allow the former Attorney General to speak freely, preferably in front of the committee that hopefully will be meeting to investigate and to interview those 9 witnesses.
I can think of a few cases where Mr. Harper refused to waive privilege. Nigel Wright comes to mind.
If the client here is the Prime Minister, Mr. Mendicino, will he waive privilege?
Well, that's not a decision that obviously has been taken yet, but I know that the Prime Minister will, in consultation with the Cabinet, refer to the principle itself, as I mentioned before, and it will be taken in consistency with the way that privilege has been respected to obviously ensure that when the Attorney General provides advice to the government and council, that it's done with all of the constitutional principles that I've referred to in the best interests of Canadians at mind.
Mr. Rankin, you're also a lawyer. Who in this scenario do you interpret as the client?
Client is the Government of Canada, the Cabinet. I agree with what Marco has said about solicitor-client privilege. It's a constitutional privilege. I also agree that the client can waive that privilege. But the broader question here, Vashi, is that the former Attorney General was fired by this government from that role, and in her leaving, in an unprecedented way, said the following: speaking truth to power was something that essentially caused her to leave. Now, I'd like to know what she meant by that.
Yeah, we would too, but she's not saying anything. And to be fair, that statement, it definitely was, eyebrow-raising. She didn't explain. She also talked about political interference. It was ambiguous. So we can't conclusively draw the link between what happened yesterday.
I would agree.
And that.
Here's what isn't ambiguous.
Why doesn't the government want to clear the air by letting the Justice Committee do its job?
That's right.
So
Can I respond to that?
Yeah. Will you let the Justice Committee do its job? Is, for example, are the staffers in the Prime Minister's office willing to go before the committee?
Precisely.
Obviously, we respect the work of the Justice Committee, as we do with all parliamentary committees. We respect that they are independent, which is to say that the members are there to obviously adhere to the rules of procedure when it comes to the committee, and the Liberal members certainly will take those decisions in due course. But with regards to what has been said regarding Minister Wilson-Raybould, she was not fired. That's a term that is attributable when somebody has done something that merits taking them out of the job. She was assigned a new She was assigned a new portfolio. That is work that is important to Canada. It's important to Veterans Affairs, and people who use the word fired are doing so for partisan purposes to score political points, and it's inappropriate.
Do you agree, though, that the statement that she posted afterwards would certainly raise some eyebrows and lead to other questions about why she was moved? She talked about having to, the optics of political interference. She talked about speaking truth to power. Do you understand why your friends in the opposition are asking those questions?
Her statement made reference to a number of constitutional principles, which I know she applied and which our government has applied when it comes to the justice system. And I know that that's something that we all feel collectively, as I said before, we place great value in that principle. But to go one step further and say that it's eyebrow-raising simply because she referred to principles which are well established, I think.
Have you ever seen somebody leaving a portfolio like the Justice Minister ever do something like that?
I think ministers, when they have been assigned new portfolios, have spoken about the pride in the work that they have taken. Perhaps this was a bit more of an elaborate statement, but at the end of the day, she talked about those principles. Those were principles that she applied in her past role as the Minister of Justice and Attorney General of Canada. She also talked about the pride that she took in that work, and she also talked about the new assignment that the Prime Minister gave to her in providing support and assistance to Veterans Affairs. And as a member of the team, obviously that's something that she takes great pride in.
Ms. Raybould, is that fair, or is that statement unique from where you sit?
Jody Wilson-Raybould can sort this all out for all of us by telling us what exactly happened, and whomever the client is can waive the privilege so that she can appear before the committee, and the Liberals can let us have the committee, and we can stop speculating about what words mean and what happened and what didn't happen. Quite frankly, what's at matter here is the fact that there's an allegation of political interference in a prosecution of a criminal matter. That warrants an investigation. It's going to start in the parliamentary precinct where we have some power to move quickly. And I'm grateful that Murray decided to sign the letter and that they've decided in the NDP to move forward to ask the Ethics Commissioner to look into it, because this deserves to have attention. Canadians want to know what's going on. And it's our job as parliamentarians to try to clear the air, at least on what's going on.
What would the Justice Committee, Ms. Raybould, what is your party looking for it to actually ascertain?
Well, I want to know, quite frankly, who had conversations with the Attorney General of Canada, whether or not they told the Attorney General of Canada that she should be taking a certain decision with respect to this criminal prosecution, and finally, whether or not she was fired as a result of not towing the line for the PMO. Those are questions that need to be asked. You can't have any cabinet minister or prime minister telling the Attorney General of Canada to go and do something in a prosecution. That is not allowed.
And I agree entirely with what Lisa said, and whether or not it was powerful influence versus, quote, directed, as the Prime Minister says, the context is critical here. We know as a fact that dozens and dozens of meetings took place with SNC-Lavalin on which the words justice and law enforcement were involved. Now, what could that mean? They weren't talking an infrastructure project. They probably were talking about something to deal with, I know, justice and law enforcement. And then we heard that there was this Mr. Marco doesn't want to call it firing, so I'll call it removal of the Attorney General. And then she did this unprecedented statement to the media and to the world on Twitter saying that she spoke truth to power and is no longer in that job. In that context, Canadians have a right to know the government owes it to itself to clear the air. This is a very serious concern.
But to be fair, the government has said that the allegations are false. What we don't know is, for example, in the Globe, the allegation that heavy pressure was applied. That's the term that was used. We don't know what pressure is. Is it possible, for example, that Minister Raybould's impression of pressure is different than somebody else? Like, we just don't know the details.
Exactly, and Canadians deserve to know those details.
Can anyone other than the minister provide them, though?
Let's see what people under oath in the Justice Committee say, people in the PMO and other places. Let's see what they have to say.
And I go back, sorry, Mr. Mendocino, I just want to go back to the point that they're both raising. It would appear that at least those answers are able to, we would be able to get them if those people would appear before the committee, if the minister would appear before the committee. Is the Prime Minister, is Cabinet willing to waive solicitor-client privilege in order to have Minister Raybould appear before that Justice Committee?
The committee will undertake that question and will come to a decision on its own, independent from any external influence.
If called to appear, will everyone from the Prime Minister's office who is called appear?
And obviously, those are decisions which will be taken in due course. But I will say that we do respect the decisions of the committee, as we have done in many other circumstances when either the Justice Committee or another committee has asked witnesses to appear before it to provide evidence. And with regards to the central allegation here, because I think that is really at the crux of this. I mean, everybody knows, or unless you were living under a rock, about the SNC-Lavalin case. So conversations obviously will have been had right throughout the various aspects in life in which we live. But there was no direction, there was no pressuring. That's something that the Prime Minister has said.
But that Minister Raybould has not said that.
That's right.
No, he hasn't.
And with regards to Minister Wilson-Raybould, I believe her statements obviously speak for themselves.
They don't say anything.
Ambiguously.
Certainly,
With respect,
I
they
think
don't say anything.
I think her statement, both about the work that she did as Justice Minister, as well as her ongoing work on the Veterans Affairs files, as a member of the team, does speak to her commitment.
I guess I come back to the
government.
point, though, that she has never come out and said the Prime Minister didn't pressure me, and her silence, I think, to many people speaks volumes. Unfortunately, I have to end on that point, but thank you to all three of you. SNC-Lavalin is no stranger to legal problems, it seems. What does this latest controversy tell us about the company? Jennifer Quaid is a law professor at the University of Ottawa who specializes in corporate and criminal law. Before that, she was a criminal lawyer in private practice and a lawyer with the Federal Department of Justice. Hi, Professor Quaid. Nice to see you. Hi. Thank you very much for coming in. I want to ask you about SNC because I know that you know a lot about the legal history, I guess, of that company in a second. But I want to start off by asking you a bit about what Minister Raybould put forth today as a statement in response to a lot of questions she's obviously been receiving over the past 48 hours or 24 hours, whatever it's been. She said that she basically pointed to she could not comment on the situation because of solicitor-client privilege. And my question to you is, does that extend to something like just saying, no, I was not pressured?
Well, I mean, obviously what is covered by privilege is always going to be subject to a little bit of interpretation. I would say that lawyers, for the most part, are careful about solicitor-client privilege. They don't want to mistakenly reveal too much. I would say that sometimes confirming or denying something might color a larger context. So maybe she's just preferring not to say anything rather than trying to assert something that actually, was there or was there not pressure. You could say she can have her view on that and others could have their view on that. So by not saying whether there was or was not is rather probably the safer course for her, I would say.
Okay. Beyond the political controversy, this company has a very long history in the courts and really with controversy. Can you go over what you think are the sort of most important points about why this company is controversial?
Well, SNC-Lavalin is a company that does a lot of its business in infrastructure. It's consulting and project management, engineering, and in that space, you tend to be soliciting large contracts that are, for the most part, public, so funded by either governments or countries, local municipalities. And in that context, there is, I suppose, the potential for things to happen as you're bidding for tenders, as you're trying to find out what the client wants. You come into contact with lots of government officials and so forth. So it's an area where, and it's an industry where you might see behavior that could end up being qualified as corruption, for example. So that industry is already, you think of construction, think of the various companies that the Charbonneau Commission, the various types of industries that were targeted there. They were engineering firms and infrastructure-based construction, that kind of thing. Now, that's not to say that all companies who are in this business, engage in corruption, but it's just saying that the opportunities exist there. And so, the chances that you might run into situations where there could be a debate about what happened is certainly there. The risk is there. That said, of course, in SNC-Lavalin's case, there have been some occurrences that have been revealed, and not just one. The subject of the prosecutions that are before the courts right now are under the Corruption of Foreign Public Officials Act, and that relates to corruption that occurred in relation to projects in Libya. But just last week, we also saw plea bargain of an executive who was responsible for dealing with the Montreal hospital, super hospital contracts. So, this isn't just a case about what happens in foreign countries where sometimes, and I'm not sure it's entirely fair to say that, there's the suggestion that that's how business is done there. I mean, clearly we don't want to suggest that that's how business is done here. But I think that there clearly in the past were, at least within the way that the company was organized, it seems like this kind of thing happened. There's a bigger question, I think, as to whether there was perhaps a lack of oversight and maybe a lack of procedures and processes to pick these things up. The company says now we've done everything, we've changed it all, right?
Does that qualify the company though for? I mean, obviously the prosecution decided not to pursue a DPA, but this idea, can you explain a bit more about this idea that they say, well, we've made these changes where it's not the same people running the company, it's not going to happen again. What does that mean to you?
Well, taking it at face value, that's good if that's what's happened. I mean, the devil is often in the details, and it's not enough to enact a new corporate policy. You also have to make sure that the leadership message coming from the top is that this is the way we do things now, and that there's training and, if necessary, other things done to support the actual achievement of the objectives of those policies. So it's not just a paper exercise. But I mean, on the surface, it seems like that's the right thing to do. One of the things that, does sometimes niggle at me is that the focus and the language often is used, oh, well, there were these people who did these bad things. And yes, they happen to work for us. And, yes, we'll answer for what they did. But really, the problem was them. We got rid of them. And the reality is that is not always a sufficient analysis of why these problems occurred. And, my area is corporate criminal liability, but particularly organizational criminal liability. And that's looking at systemic and more culture-based, and by which I mean an organizational culture problems. There, it's not enough to get rid of one person. And usually, if there's a practice or a series of practices and you see multiple occurrences, this is not just one person, one bad apple. Maybe there's something wrong with your barrel in which your apples are sitting.
Is there cause for concern when you see the lobbying history of this company and the idea of the DPA brought in through the budget implementation bill from where you sit?
The process by which this new part of the criminal code was enacted is definitely something of concern. I mean, those of us who watched it happen were sort of astounded at how it just floated below the radar and then happened. And in my mind at the time, I was thinking, I bet the first company who's going to want one of these is SNC.
Really?
Now, of course, it's an open secret. Everyone just says, oh, of course, it was always for them. But at the time, you're thinking, wow, you're making a major change to the criminal law, which you slide into the budget bill, no time for analysis.
Why did your mind go right to SNC?
Because they're the biggest company with a corruption problem right now. And also because the remediation agreement is, we call it a remediation agreement, it's Canadian-style DPA, is not applicable to all criminal offenses. And in particular, one big gap, which I noticed at the time, is competition offenses, because they have their own immunity and leniency program. I think eventually that's going to have to be folded together. But that's actually where more prosecutions in the recent past have occurred. It's with price fixing, bid rigging, and that kind of thing, and not so much corruption. Canada had been perceived in the international arena as being a bit slow on the uptake in terms of taking steps against corruption. And this remediation agreement was sort of part of that overall shift. I mean, also the fact that now we changed, we used to have a very limited view of what things could be prosecuted here. We sort of brought ourselves into line with the international expectations there. And the remediation agreement exists because in places like the US and now the UK since 2014, also Australia is coming online, and France, let's have some things happening. Those big players have this option to negotiate a DPA. And so the argument of Canadian companies, but in particular SNC-Lavalin, was we're at a competitive disadvantage if we don't have that option. And that's fair enough as far as it goes. But one of the biggest arguments, at least this government made when they said, look, we've got this brand new regime and here are all the benefits. One of them is we're going to discover things we don't already know about, and we're going to encourage a compliance culture. Well, SNC doesn't fit in that story because they were discovered, right? There was an investigation, they were found out. They didn't come forward. And And that's, not helpful. They have made corrective measures. That's one of the things you consider. But, the remediation agreement is supposed to be an opportunity for companies to come forward and also, in some ways, to proactively supervise.
All right, I have to leave it there, but thank you, Professor Quaid.
Thank you.
Appreciate your time.